Hey guys, welcome back to another episode of the Area 51 podcast. Today we've got a very special guest with us. We've got Anna, who is otherwise better known on X as the H-1B queen. And she's got this term because over the last couple of months, she's actually put on a stand for us and defended the H-1B programs and all the H-1B workers for many sleepless nights. And I've seen her actually pay the price for it many times. Every time when I think that's it, she comes back the next day more vocal and more stronger than ever. So welcome to the show, Anna.
Thanks. It's a pleasure to be here. I've never been very good at shutting up, so it's not surprising that I keep coming back and saying more about it. I can't take it when the bad information comes through. I'm like, "Oh, I have to fix it." So it's a pleasure to be here.
So before we get started, you want to give a quick introduction about yourself, Anna, for everyone else who's tuning in?
Yeah, so my name's Anna Gorisch. I'm an immigration attorney. I went to Georgetown University Law Center, and I have, over the course of my career, mostly focused on the employment-based categories. I've done a lot of H-1B and PERM, and I've worked at large firms like Fragaman, and I've worked at small firms, and I've been in-house. So I've seen the system from multiple angles and have insight into, what it's like at a big firm and what the challenges are there, but also what happens on the employer side, which I think is often neglected in the conversations. We talk a lot about the employees, but not too much about the companies themselves and what they engage in to employ H-1B workers.
Gotcha. And I wasn't kidding when I said that you have received a lot of backlash on X for standing up and supporting the H-1B program. And I have seen your posts and you've been very transparent with it, right? And there was a time when they actually tried to sabotage you and the clients that you supported. And I was so surprised because that took it one level over the platform, right? Everybody trolls folks on X, right? But this went one level higher than that, almost bordering or cyberbullying, if you ask me.
There were a few things that happened, but my favorite is that people would Google my name, find my law firm, and send me a message asking me to fire myself. Because they don't realize that I am the only attorney at the firm. So, I was tempted to respond and say, well, I've given myself a good talking to, and I think I'm going to do better. So I'm going to keep myself now, but I did put myself on a PIP.
On a PIP.
And, I've gotten some hateful messages through my website too. And at some point, I just turned off notifications for unverified accounts or something, because for a while, I would get comments that actually bothered me. Yeah. Some of them get pretty ugly. A lot of them get into racist stuff. And often there's some accusation that I'm Jewish and that is why I'm this way. I don't know. But yeah, it's okay. I can take the heat. It doesn't,
No.
If it gets too far beyond Twitter or X, then I'm going to have to step back. But
But you've never considered not being vocal even after going through all this?
No.
That's
Again,
easy.
I'm not very good at shutting up. And it's something I really do care about. It's very boring and mundane, the H-1B. It's, something that, it's been around since 1990. But I just find the category and all the controversies around it and all the challenges in the program really interesting. And, I have a lot of ideas for reform. I think people assume that when I explain how the law works, I'm saying that's because this law is awesome. I'm not necessarily saying that. I'm saying this is the law.
Right.
So, a lot of people are not happy to hear what the law actually is.
Yeah. And you keep fighting the good fight. So before we get started on the episode, thanks for standing up for all of us. Some of the posts that you make, I see and I'm like, wow. We do it because we face the wrath of the system or we face the challenges, but you're doing it because you see that it's wrong, right?
Yeah.
You're in it day and out, and you stand up for what you think is wrong, and you pay for it, right? It does take a toll on your mental health.
Yeah, I mean, you learn to balance that. But again, Because I know how many H-1B holders are probably not going to advocate for themselves too aggressively because you're worried about losing a job, you don't want to
Absolutely.
jeopardize your status, but I can say it. There are plenty of organizations dedicated to the humanitarian cases, the asylum cases. There's a lot of attention on that, but I
Right.
feel like those in the employment-based system are just invisible.
Yep.
And to the extent they're noticed, it's based on wild misunderstandings of the way the programs work and what the requirements are and what the realities are for employers.
Well, on that note, Anna, we're going to jump into today's topic. I thought we'd do something a little lighthearted. Well, not
Okay.
exactly lighthearted, but something that I find to be pretty funny because the more I talk to people, the more I realize that folks don't actually know the nuances of the H-1B program or the visa program, right? And there's just so many assumptions based on top of assumptions, and they're just running with that narrative. And you see that everywhere, right? You see that in articles, you see that any politicians, you see that on X, you see every regular person having a narrative that which they think is right, and they just run with it. I posted on X prior to our recording, right? And I thought we'll see what the audience feels like they want to talk about, and I got a whole bunch of questions. So I thought
Yeah.
we'll try dive down into a bunch of them. The first one, the Microsoft layoffs. Right? Microsoft laid off about close to 10,000 folks a month back, right? And what was going on was that they laid them off, and they looked at some data points and said that they hired an equal or more amount of H-1Bs to replace them. Right now, I know that that is incorrect because there are many folks in Microsoft who got laid off who are on the H-1B program themselves. Right?
Absolutely.
I wanted you to break down on why it's not possible for a company to lay off a certain number of people and then hire just a certain amount of people right then and replace it like that, and how the data points that they pulled were filings that were done almost 7 to 8 months ago, labor filings that actually showed that they needed a requirement about a year ago, which due to the slow processing of certain organizations just happened to get filed and completed right when they had the layoffs. Those employees in question might not even be associated with the company, or those petitions might not even be filed.
Exactly. Yeah, and so that's one of the biggest problems we have in the dialogue with people and trying to help anybody understand it is because the LCA data is public and people conflate it for H-1B data, but it's not. There, first of all, you have to file an LCA for an E3 worker as well from Australia or for an H-1B1 worker.
Yep.
So it's even the LCA itself is not limited to the H-1B. But you're right. All the LCA is an attestation to the Department of Labor. When you start a petition process, you go, "Hi, Department of Labor. Here are all the rules. Here's the wage I have to pay him. I'm going to sign this under penalty of perjury and promise we're going to pay these wages." And then it goes to the Department of Labor. And in almost every instance, in about 10 days, you get it back certified. It used to be a long time ago in 2008, they were certified immediately. Like as soon as you submitted it, it was certified. It would come back certified.
Sounds like a dream.
Well, yeah, because there's really not much review that needs to happen at that stage.
Yeah.
It's not something that Department of Labor is going to delve into and really explore. And I think that so people see this LCA data and assume that it's petition data, it's H-1B data, but it's not. And it's so what you're describing there with the LCAs and the vast, I don't know why anybody would understand any of this. None of it is intuitive, although some people seem allergic to information. So we're talking about the Microsoft layoffs.
Yep.
You can file an extension request up to 6 months prior to your expiration date, right?
Yep.
And I can promise you that every single individual on an H-1B visa, the minute it is 6 months, they are reaching out to the law firm being like, "We're starting my process, right? We're starting my process, right?" They always want to start immediately at that 6-month mark. And it can be hard to do that for everybody, but I mean, most firms will try.
Yep.
So part of that is that you're looking at LCAs that were filed and certified for an extension that's, like you said, 6, 7, 8 months old, and it may never have been filed with a petition. That does not mean that somebody was laid off. That does not mean it's a new job. Furthermore, any recent LCA data, I guess we're in Q3 now. So in Q3 of fiscal year 2025, you're no longer looking at H-1B, like the LCAs are no longer cap petitions, right? So that with that October 1st start date.
Yep.
So when you're looking at more recent tables, you're going to see mostly people who had extensions, coming up. You also file one with a change of employer, so it could be that. But yeah, there's
Or
no
totally different orgs within the company, right? Microsoft Beast, you've got multiple orgs. You could have someone requesting an extension from a totally unrelated department from the one that had its layoffs, right? It's not like Department A had layoffs, Department A hired equal or more number of folks.
Exactly. It's not a replacement. It's not we're, letting go of these employees and replacing them with H-1Bs. As you mentioned, H-1B workers have been included in these layoffs.
And I know many folks who've been hit by that wave.
Yeah. I often get consultation requests for somebody and their story is, okay, I just got laid off. I have 60 days. What's my best strategy, right? So it's absolutely false that H-1B workers are not being laid off as well. And you also have to look at some of the departments that they cut. The first round of layoffs, I think, was a kind of a general across the board layoff, but later they decided to cut things like sales. And that's probably not where your H-1B workers are. So, if they're cutting down on sales staff, and then I think there was a Reuters article that they were mostly targeting like layers of management, right? Eventually a company like Microsoft has about 15 layers of managers.
Yep.
Right. So I think that people see that, there were layoffs at Microsoft and assume every job at Microsoft must be a computer IT job. It's not. And then they see this LCA data from last year and go, oh my God, they're sponsoring all these new H-1Bs as soon as they lay off these people. Yeah. And again, it's like you said, we don't know from LCA data whether the employee is still with the company. It wouldn't show that. Or whether the, person was laid off before they ever got to file a petition. So it's untrue that people in H-1B status do not get laid off. And I think you mentioned at the beginning of this that layoffs also get very, very tricky because there are rules around them. There are restrictions on sponsoring new H-1Bs if you've had a layoff. One of my favorite talking points you see all the time in the media is, they made me stay and train my H-1B replacement, and it was so humiliating. I had to stay for 90 days just to get my severance. And I think, wow, nobody else would get 90 days notice plus severance. That sounds pretty great to me. But the other thing is, they're not staying to train their replacement. If you've hired an H-1B worker, you can't lay anyone off for 90 days. So it's basically a compliance thing dressed up as, okay, here, help your replacement figure it out. And it's not a system where the H-1B workers are just too stupid to do the job and it takes them 90 days to get them up to speed or something like that.
And also, if a company's had a wave of layoffs, they're not legally allowed to file any PERM applications as well, right? And PERM applications are the first step towards a green card. So
usually,
So if you think, usually correct for your regular EB2 or EB3 routes, right? Accepting the NIW ones. But so if you're thinking that layoffs are happening and then you're filing so many applications and getting them green cards, that's, again,
absolutely not true. Yeah. And in the PERM context, there's almost no flexibility. I think people don't understand that there are legal checks in place to make sure that companies can't do what everyone thinks they did, which is that Microsoft got rid of a bunch of white guys and brought in a bunch of H-1Bs because they're cheaper, which is also false. The public perception of this issue is not aligned with reality, I don't think. And I think people miss that there are built-in protections for U.S. workers, like you can't file a PERM, you can't file employment-based sponsorship if you're, having layoffs.
And I don't blame the general public because it is a complex system, right?
Oh, sure.
I've been in it for almost a decade now, and even then there are so many parts I don't understand completely. So And I keep joking with folks that, you come here for a grad school degree, but you end up graduating with a minor in immigration law as well, because you
Oh,
have to
yeah.
stay. So we don't blame you, but it's just whatever articles or headlines you see, or narratives that you see on a lot of social media platforms, right? Try to dig a little deeper into it, because there's always, like Anna said, the government has placed checks and balances in place to ensure that, priority is foremost towards American citizens. If you're filing for a PERM for a position, you've got to first show that there is no qualified American citizen or permanent resident who can fill that role. So when they're doing a labor market test, if someone else applies for the job, you can't proceed with that person's PERM application, or go the labor test fails.
Exactly. And you just kind of stop the process there if you receive an
Yep.
application from someone who's clearly, and there are 4 criteria: qualified, able, willing, and available. So, for instance, if somebody was qualified but unwilling to accept the salary, you could still proceed. If
Okay.
somebody was unwilling to relocate, you could still proceed. It's not simply, well, this guy meets the criteria, that's it. Sometimes it's worth it to follow through and see if they actually really want the job, talk to them, make sure they do have the experience. But, I have never worked for or advised any company ever to make up reasons to turn away U.S. workers. That is not something lawyers are allowed to do. You cannot do that, and Department of Labor will come down on you. Again, the idea that this is not a regulated system is also false.
Since you mentioned salaries, right? I thought it was a segue into the next one that I saw pop up quite often. Are H-1B holders paid below market wages? Are they severely underpaid compared to their American citizen counterparts?
Absolutely not. Not generally, no. And we'll talk at the end about the exceptions, any kind of red flags within the system.
Yep.
The Department of Labor conducts surveys every year to figure out how much people are paid various experience levels within a metropolitan area. It's not a national wage, it's the locality, because the cost of labor in Omaha, Nebraska is different than LA. So once they get that data, they determine 4 levels of the prevailing wage, right? And so level 1 would be appropriate for a job that required a degree but not any experience. Level 2 is going to be, a degree plus a few years. Level 3 is even more. And then you get into master's degree calculations and things like that. Anything that requires a master's plus 3 or a bachelor's plus 5 comes in at that highest wage level. And those are not low salaries. In Silicon Valley, the prevailing wages for software developers, which is probably the most common category here, the prevailing wages are in the 6 figures, like from the first, with no experience, it's already up in the 6 figures. So they are not cheaper. And then you have to factor in that not only are they paying an attorney to help manage the legal compliance and the filing, they have to have in-house personnel to manage the internal compliance. So that's a head count. They pay the attorneys to do this. And then the government filing fees are quite high. And because some of the larger FANG companies have so many H-1B workers, they're classified as H-1B dependent. And they pay an extra $4,000 per petition. So to file one H-1B,
is it greater than 50%?
No, it's not even. I can't remember that. I can't remember the percentage, but it's not. It's less than that.
That's crazy. Okay.
But so I mean, an H-1B petition itself costs a company like Microsoft $10,000.
$10,000. Yep.
And then you've got the wages too.
Just to break that down a little bit more, so we break that down into different employment codes, right? Those employment codes, when you file, they will look at what locality you're filing from, and then based on that, if you hit the threshold, only then will your petition be approved.
So the prevailing wages are not low. And in fact, to the extent that they ever depress U.S. wages for U.S. workers, you have to remember that not every company is Facebook or Google. And for companies in other sectors that rely on the H-1B, but don't have huge profit margins and they have very tight labor budgets, if they are facing, okay, I've got a critical employee here and we've got a deliverable and I have to pay him the level 4 wage, which is above what we normally pay for the role,
Yep.
what am I going to do? And often what will happen is, because the law requires them to pay that higher wage to the H-1B worker, the labor budget gets squeezed for the U.S. workers and they make less. So the prevailing wage system is not without its problems, obviously.
Yep.
But, H-1B workers are lots and lots of things. Cheaper is never one of them.
I'm glad that you clarified that. And whatever Anna just spoke about right now, the level 1 to level 4, that's the system that the department's using to actually revamp the H-1B lottery.
I think it's insane, but we'll see what they actually come up with and whether or not the rule is approved, or that they'll probably face litigation. So we'll just have to see how that goes.
Yeah, because the last time they tried it, I remember that pretty well, because it seemed almost like tech salaries were the baseline. And my friends from St. Louis, Missouri were saying that, a salary for like an entry-level engineer was almost 6 figures plus in St. Louis, Missouri. And that was like unheard of for like a non-tech background. So I hope this time around it's done a little more kindly, for lack of a better word. Yeah.
We'll see. One of the tricks is that it seems, in my opinion, it contradicts the statute, because the H-1B is not, and this is another thing that's repeated all the time, and it's not true, is that it's for the best and the brightest only, right? The way it's defined in the statute is that it's available for any job where a bachelor's degree is a minimum requirement for entry into the field. That's it. It just means skilled worker. You've got a degree. You're doing a job that's complex enough to require a degree, and you have the right degree. You can do the job. You can use the H-1B for that. If they lean into the level 4 wages, what's odd about that is that, and probably a lot of your listeners know, the most common path is you come here, you get a master's degree, you do your OPT, you do your STEM OPT, you hope to get picked up in the lottery somewhere in those 3 years, and then you start working on your H-1B. At the level 4 wage,
exactly,
that's going to rule out a lot of entry-level jobs. The level 4 wage is really high and would mostly apply to people who already have an H-1B. So that's what I think is going to be interesting too, is to see how many initial cap subject petitions as a result of the lottery use the level 4 wage. I bet it's tiny. I could do some research. I'll post it on X when I find it.
I don't know. We'll see how it goes, because you've got the director of USCIS saying that he wants to cut down on OPT, which is that 3-year bridge that folks get into this thing. And then you have level 4 salaries to start with. If folks are not careful, we probably will end up with a shortage, because according to a lot of the statistics that I've seen online, and I actually did an episode with someone called Sam, who is a policy analyst, there is a shortage of STEM graduates. The folks who do want to come here and study and help fill that void, we're actually trying to turn against them. I don't know if it might be like a catch-22 down the lane if you're not too careful.
Yeah, and that's going to be tricky too, because OPT and STEM OPT are creatures of the code. They're not in the statute, so they're a bit more vulnerable to being changed. So yeah, but I did see the statement that they want to try to make it clear that if you're coming here to study, you're going home when you're done. I don't know why they're being this harsh. My best guess is that they've faced so much difficulty in removing anybody that they're kind of at a point where they're like, how about we just don't let anybody in? Then we don't have to worry about removing them.
I like the way you answer, because there's enough points to segue right into the next question.
I didn't even do it on purpose. Wow.
You mentioned you need a degree to qualify for an H-1B, right? So let's talk about H-2B, seasonal employment, right? I keep seeing PERM certifications for like cooks, for like short-term seasonal farmers or handymen to help in the farms for like, $20,000, $30,000. And the narrative is that, hey, are these the folks we want coming in on H-1Bs? And People don't seem to understand the fact that there's an entire class of visas called H-2Bs, and there's totally different Bs than
Right.
H-1Bs, and these all fall under that category, right?
Yes,
And
there's also an H-2A. So the H-2A and H-2B are for seasonal and peak work, like you noted.
yep,
H-2A is typically agriculture.
yep,
And then H-2B is broader, construction, any company that has like a peak load or a season where they need extra support would use the H-2B. Neither one of them are dual intent, which means that you're not allowed to intend to become an immigrant. So it's strictly temporary. These folks usually, for the H-2A program, farms that can afford to participate, because a lot of small farms have been priced out. They also have a prevailing wage problem that's similar. But a
oh,
lot of these farms will hire the same teams year after year and bring them up for the season. But the H-2B, it's broader, right? And I mean, this is a segue into something else that I think we were going to talk about. But one of the things we've been seeing is, oh, look at all these H-1B truck drivers.
yep, oh my God, yes.
That's also not a thing, but there might be H-2B truck drivers.
Right, so that accident that we saw recently,
Yeah.
right?
Well, that guy was not here with any lawful status, apparently. And I think that that's more of a problem with states like California giving CDLs to people who maybe aren't qualified. They're failing the ability to read signs or read in English, which you just have to be able to
Yeah,
do to navigate the roads safely here. So my dad drove a truck for a while after he quit his music career. And so I know a little bit about the trucking industry. And what he did was, I mean, unbelievable.
I
Like,
saw
there's
that.
no way he was educated by any kind of professional trucking
Yep,
program. I certainly hope not. You do not just turn left in the middle of the interstate. I can promise you that because those jobs do not require a degree, they are not here with H-1B visas. And yes, I did find a few LCAs for truck drivers. Most of them were denied, and there were only a handful anyway. And again, remember, an LCA is not a petition. And so a lot of times companies, not understanding the rules or the law, will look online and say, oh, if we want to give this guy an H-1B, the first thing we do is file this LCA. So let's do that. And they don't think about it beyond that. They don't, maybe they try to do a petition, but you got to remember that's a public website, and it'll tell you something if you're going through the data and you don't see any attorney information listed. That's the other one I get all the time, is that I'm just doing this to be rich, honey, if only. But it's yeah, truck drivers, they're not here on H-1Bs. If you don't see a law firm or a lawyer listed in the LCA data, then it's probably, it's going to be immediately suspect, because as much as I hate to say you really need an attorney, but you really need an attorney, because again, the stuff is not intuitive. And I'm not saying that because I get really rich off selling H-1Bs. That's not how this works. But you need an attorney, just because there are so many little tricks and traps that you won't know about. And it's like we were saying, it's not intuitive. And so I have seen a lot of very smart people tell themselves, oh, it's just filling out forms. How bad could it be? And do it themselves and end up with a very expensive problem. So anybody out there who is hesitating and considering filing something for yourself, maybe at least talk to an attorney first, just to get some feedback. But yes, so if you don't see an attorney name on the LCA, that means that they don't have anybody advising them on the requirements for the H-1B or managing their filings. So, it's a lot of data, and people can cherry pick what they want to post and say, I found an LCA for a truck driver. Look, that means all the H-1Bs are coming here and driving our trucks. And it's just not true. Until it requires a bachelor's degree from a university, there will be no H-1B truck drivers. But you
thanks.
may see them in the H-2B context.
Ever since that accident happened, right, all I've been seeing is, oh my God, now the H-1B guys are creating problems on the road. Now we need to get them out, deport all of them. And I keep telling them, like, guys, like, just pause, take a minute. Like, They're totally different visa category. They're not on an H-1B, I can promise you that. And the same for the LCA stuff, like you said, right? They get posted. They're like, oh, a cook's coming here on a $30,000 H-1B visa. Why can't we fill that internally? I'm like, that's not an H-1B again, right? So you guys are using the wrong data points to run this narrative that you got going on.
And let me promise you that while Department of Labor does not do a thorough review of any LCA, USCIS absolutely does. And if you file a petition that includes an LCA with a wage they think is too low, they'll issue an RFE, which, again, you know what that is probably, and a lot of your audience does as well. But for anybody who doesn't know, it's a request for additional evidence. It means USCIS is saying, I'm not buying this. And what you would probably get pushback on in that instance is whether it's truly a specialty occupation. Does it really require a degree if you can pay them a level 1 wage? This is not the right wage for this. This is the wrong SOC code, whatever it is. USCIS will push back on an LCA if they think that there is something shady in the LCA, or they're not believing that it actually is a specialty occupation. So just a certified LCA could still be an H-1B a denial.
Well, thanks for pointing that out. Going to go on to the next one or two questions that we've got. One, another very popular one, folks on an H-1B do not pay Social Security taxes, but they benefit from all the government programs that are there, for like food stamps and whatnot.
I'm not sure how that got out or why anybody would think that. It is true that F1 students do not pay Social Security taxes, but H-1Bs do. And it's like you said, the challenge with accepting any kind of government benefit, one of the grounds of inadmissibility is that you would become a public charge.
Yep.
Meaning we've got to support you, right? If you were to go on food stamps for a while or something of that nature, and then you get to the part where you're ready to get your green card and you file that I-485 application and you have to check, yes, we got SNAP benefits, you're going to have a problem. You're going to have to prove to USCIS that in the intervening time, you've made so much money that it'll never be a problem again or something. Even if you could be eligible, and I'm not at all sure, and that may be a state-by-state thing. A lot of this stuff is decided at the state level in terms of, public benefits, but it could harm your adjustment of status case when you get to that.
I want to use this as a learning moment for everybody else. A lot of folks, partly due to not having enough information, they file for unemployment benefits when they lose their job. Don't do that, because if you do, you all these things put you in that bucket of a public charge where it could very seriously impact your green card petition when it's in the final stages of approval. So don't do that.
See, that's why you got to talk to an attorney.
Exactly. I don't remember who it was who said this. Somebody said it's on a previous podcast episode, right? They do monthly or periodic check-ins with an attorney like they do with a doctor, right? And I was taken aback when I heard this because it was very unique. He's like, no, it's my immigration case is just like my other health problems that I have. I do periodic check-ins every 6 months to just get a check saying that, hey, things are good. You're on the right track. Whatever questions you have or whatever things you're planning for the future, that's probably the right way to do. And it just blew my head when I heard that. I can't recall who it was who said it, but I totally love that piece of advice. And I highly recommend it to people as well. Before any major decisions or some things that you're going to take professionally or immigration-wise, check in with an attorney. Maybe not your employment attorney. It's probably good to have another attorney for ask all your questions that are not work-related, right?
Yeah, and that's one thing this is also commonly misunderstood is, people talk about the H-1B, the focus is always on the worker, but the employer owns the entire process. They own the whole thing. If the H-1B terms and conditions are violated, it's almost always by the employer. You've got the employer owning this process, and that means that if you're at a big company and there's a large law firm that's managing your account or your cases, there are great attorneys at every firm and they can give you good feedback, but I think it can be wise to just check in once in a while with an attorney who has no obligation
Yep.
to your employer, does not have an attorney-client relationship, because
Yep.
as much as it seems like you are and you're so involved in the process, you're not the client. The
Yep.
employer is the client.
Oh, that's valid.
And
Yep.
so that creates some challenges too, because, people who are in the trade terms as a beneficiary, right? Because the employer is the petitioner. And so you've got the beneficiary, and, they do often have a lot of questions and they send a lot of emails, and we do our best to answer all of them, but sometimes we get behind. So I think it's worth checking in, especially if you're thinking of making a change of some kind.
Oh, I love that. Great advice. Moving on to the next one. Is it true that only Indians use or make use of the H-1B program? That was something else that
No.
popped up.
No. So this one needs a bit of explaining. But no, it's not even a tech visa. It's just for any job that requires at least a bachelor's degree. So, it could be a social worker. It could be, anything that requires a bachelor's degree is eligible for the H-1B. Now, it's largely leveraged by big companies in finance and tech. Finance doesn't get as much attention, but I promise you, McKinsey has a hefty immigration program, and other major financial centers.
Yep.
So that's not true. It is not for Indians. It is not even for tech jobs. The reason, so people will go and look and see how many petitions were approved this year by nationality, and note that the vast majority, or some huge percentage of the petitions filed for that year, went to Indian nationals. And people see that and they go, that's a brand new Indian right there. And the problem is, no, it's because you guys face a cap on the immigrant visa, right? So you get stuck in H-1B status for 25, 30 years, and you're extending every 3 years. So a lot of those cases that people are looking at and going, oh, that's an Indian national. Look at that, brand new, just off the boat or whatever. No. The reason Indians have to keep filing extensions is because they cannot become permanent residents because of this arbitrary country cap. I think it was Rep. Salazar had a bill for a minute. I don't know if it's going anywhere. The Dignity Act.
Dignity Act.
That would have addressed a few of these issues with the backlog. But that's the reason, is because your guy from, I don't know, Italy or Brazil can become a permanent resident within those 6 years because they're not oversubscribed, right? But Indian nationals and Chinese nationals to some extent, but it really hits the Indian community hardest, is that you've got the longest wait for the green card. So you have to keep extending that H-1B. You have to file a new one every time you change employers. And so the reason that of all petitions filed, a majority go to Indian nationals is because they have to file tons of extensions, not because we're hiring lots of new ones every day. Yeah. People from other countries are already permanent residents. You guys are the only ones who still have to keep submitting those extensions for years. So of course there are more, you get a larger percentage of the approvals, because you're the ones who have to file the most of them.
Oh, I love that. You summed up the immigration backlog in 2 minutes.
I hope so. I mean, it's weird to understand. It's hard to explain to normal folks and like regular people with regular brains. See, he has an immigrant petition, but he can't get his green card because there's this cap on the countries. Don't get it. It's just 7%. Like, nobody's going to listen to all of that. But just trust me that the reason that there are so many H-1B workers from India is not because they're disproportionately hired every year. It's because that country cap is there. And so they just have to wait until their date becomes current. And that's a whole wacky process too. Because if you had your immigrant petition approved in 2012, which happens. I think 2012 might be current
Yep.
now.
Yep.
And say, you haven't left the US or the company, which, is rare, but it could happen like 15 years later or something. You're able to file your adjustment of status, and you're filing it based on a labor market test that was conducted 15 years ago or whatever. So what good is that at that point? The whole PERM process is the most expensive dog and pony show in immigration law. And it is so outdated. It is so stupid. And I understand why Americans get upset about it, because it's really not a job. It's not an advertisement for a job. It's a test of the labor market, and people seem to think that if you get a qualified worker who applies via PERM, that they must get the job. That's not how it works.
Yep.
You just don't move forward with the sponsorship. So, having been on the job hunt end of life, I think it really sucks. You'll see a job that you're like, oh my God, that's exactly what I want to do in my degree. I'm going to apply. And it's not a real opening. But the thing that people don't understand is that employers have to do it. They have to do it. It's dictated by law. It's not something the employers choose to do. I've seen a lot of people commenting that it's ridiculous that they choose to advertise the job in 2 consecutive Sunday papers. And I'm like, yeah, it is ridiculous. Nobody goes and gets the Sunday paper anymore and sits down with a cup of coffee and a pencil and circles the jobs they want to apply to. So I get why you think it's stupid, but that's the law requires it. The problem is the law. The employer is not the one being like, let's just drop it in the Sunday paper and then nobody will apply. It is always on the state workforce agency job board. So whatever your state is, they'll have a government job board. So those aren't hidden. You can't hide those. But the thing is, I don't think that white collar workers tend to go to their state jobs board when they're looking for jobs. So they miss that. But it's a requirement. The law dictates that that's where it has to be advertised. And the law is outdated enough that of the other, you have to do 3 other placements. And they include radio ads, TV ads. I mean, can you imagine you're watching the news and up comes Meta is hiring software developer 2, must have call such and such number. I mean, like it's so outdated. It's so insane because it's just written in at a time, like when phones were still attached to walls. A lot of the difficulty in our system comes from the fact that it's so outdated. And of course, it's not intuitive. It's really stupid. So I understand everybody in the system is frustrated about it. I just want people to understand what it is, because if we don't understand what it is, and we can't even have an honest conversation about what it is, how can we ever hope to reform it and improve it? So if you don't know what you've got when you're starting, I think you're kind of lost when it comes to making any proposals for improvement. And it's amazing the number of people who will just insist that, nope, you're an idiot. That's not it. And then I'm like, I'm an immigration attorney. And they're like, that's right. You get all your money off this. So you're selling it. I mean, trust me, if you want to get rich in law, don't pick immigration. It's not that you're not well paid, but if you want to make a lot of money, go mergers and acquisitions, go do corporate something, tax law, patent law, something like that. People in immigration are not out here just banking, rolling in dough, like making it rain out here. It's not a great way the H-1B is not going to get you rich. So,
I love it. I love it. The newspaper thing cracked me up. Oh my God. It's hilarious.
Every time I see it, I think of the movie Erin Brockovich, because there's a scene where she goes and gets the paper and is looking for a job. That movie was made in the 90s. So that's part of the problem. And then, now there was a big Facebook settlement in 2021. That's a topic we could get into another time.
Yep.
But now all employers also are required, they do place it on their career site, on their website. So complaints that they're hiding the jobs don't make a lot of sense to me.
I'm going to snip just this PERM rant that you went down, and I'm going to put it out on X, and it's going to blow up for sure. I was going to get a good laugh out of it.
Well, that's fine. That's great, because it's crazy. It's stupid. And then the internal posting notice is always, like, what employee's even going to notice it? And
Yeah, I
it's
know.
just, so it's the law that's the problem, not the employers, not the employees. The law is outdated.
This was a great
Um,
segue into the second part, right? The last part, which is it's not all hunky dory, right? The program does have its flaws, right? In
it
small
does.
concept, you've got a small group of folks, right? Mainly your consulting body shops, right? Who actually game the system. They put in multiple H-1B entries. They don't pay the fair market wage. And basically all the
Right.
problems that you've noticed with the system is not a system-wide problem. It's concentrated to those few companies that do this, right? Let's talk a little bit about that, Anna, if you don't mind.
Sure. There's nothing in the statute that forbids consulting arrangements for the H-1B. So what happens is you have companies that are basically contract out, it's like an employment agency kind of.
Yep.
And they hire a lot of H-1B IT workers and then try to sell their services to other companies. And the problem is probably immediate to many, which is there's an intermediary there. So who's paying the prevailing wage? Who's making sure, that's being met? And I've seen situations where it's like one consulting company sends the person through another consulting company that finally comes to another consulting company, and then they're placed at the work site. And with that many middlemen, you got to think that some of that money is not making it to the H-1B worker. Some of these companies are notorious for benching their workers, which you're not allowed to do. And what that means is saying, we don't have any contracts for you, so no pay. If you file that H-1B, you're promising to pay, and you've got to keep paying even if there's no work. So if I could make one change to the entire system, if I only had one thing I could change, I would eliminate the consulting companies from eligibility for the program. They do not represent the majority. I want to emphasize that the vast majority of H-1B workers are here with bona fide job offers for full-time companies, but I just don't think that at the time that this was written, this kind of situation was even comprehensible. Some of these companies, and USCIS is cracking down on that registry fraud, by the way. Registering the same person 50 times, they're no longer going to let you get away with that. Again, there are enforcement actions, and we don't decide to get rid of laws because people break them. We don't decide, well, people commit murder anyway, I guess we'll just take it off the books. The solution is not to get rid of the law. The solution is to improve the law and to enforce it, because what the companies do in some of these situations is against the law. And I know that there have been major civil settlements with some of them. I can't remember which ones off the top of my head. And, so I'm not here to tell anybody that there's never any abuse in the H-1B system. Of course there is. There is in any system. It's not unique to immigration or the H-1B, but I think the solution is not to decide that the whole program sucks, but just to say, okay, these companies are prone to using it inappropriately, maybe taking kickbacks from employees, shady stuff like that. So anything like that, we should be prosecuting. And even the right will say all the time, why don't you go after the employers? Go after the employers. Well, if you've got a consulting company that's doing shady stuff, go after them. But that's why I would remove their eligibility. And that would be a bummer, because there are good contracting companies and consulting companies that really do provide, peak services, but U.S. workers want those jobs now. So I guess all the new STEM grads from Columbia who spent their years learning math is racist are going to come be your software developer now.
Oh my God, you snuck that in there.
Well, I mean, that's another thing again. And the right seems to have this disconnect where they will all acknowledge the problems with U.S. universities and our education system in general. And then they turn around and say, nope, every single job, I don't care how complex, it's got to go to American guy. And I'm like, really, you realize the education system they're coming from, and you still say that. And, I don't care if the guy designing the cybersecurity system that protects my money is from here. I want to know that he's good at his job, and so I think that, it's a rejection of merit, which is kind of odd to me. And there's an assumption too. And a lot of this is really just, as you know, targeted at Indians. They're dirty. They come over here with their caste system. They don't engage. They don't assimilate. And I have never met, and this is true, and maybe this is a good place to end. I have never met more patriotic human beings in my life than my Indian clients. They understand what it is to be here, the opportunity that they have to be here. They're grateful for it, and they fight for it and wait for it for a really long time. I mean, clearly, you place a lot of value on being able to remain in the United States. You're not coming here to make the United States India. It doesn't seem to be the plan. So, I have had so many delightful interactions with Indian clients over the years, and I have a real familiarity with how hard it is for Indian nationals in the immigration system. I have a lot of sympathy for that. I wish there was more we could do to help, but lawyers are limited by the law. So until they change the law, we'll do the best we can.
Well, thanks for saying that. It means a lot, and you already do enough, and we appreciate you for that. So, and again, I want to just iterate what I said at the start. Thank you for standing up for the program and for all of us. It means a lot, everything that you've said, and I'm super happy that we finally got to record after all our Twitter interactions.
Me too.
Back. Thank you for coming, and thank you for everything you've said.
It's my pleasure, man. And like I said, I'm not good at shutting up, so I'm probably gonna keep talking. If you want to follow me on X for tidbits of obscure immigration law, that's me.
I'll put Anna's handle in the show notes when I publish this, so you guys follow it. And I highly recommend that you do it. You get a lot of insights, a lot of humor, a lot of sarcasm, but there's a lot of useful information there, and that'll help you if you've got questions about the integrity of the program and whether everyone's out here stealing your jobs. You'll form a better understanding of the system based on what you read from her content. So I highly recommend.
Thank you.
Take care.